Hello everyone, I hope you are doing well. In this video, I am going to unfold the history of patent system in India. The topic is divided into two parts. In the part 1, let's discuss about the origin of Patent Act 1970. The history of Indian patent system starts in the pre-independence era of British rule. The first patent-related legislation in India was Act 6 of 1856, which was adopted from the British Patent Law of 1852, and it came into force on 28th February 1856. The objective of this legislation was to encourage the inventions of new and useful manufactures. In that time, the rights given to inventor were termed as exclusive privilege, which we call patent right now. And certain exclusive privilege were granted to inventors for new manufactures for a period of 14 years. In 1859, this act was amended to grant exclusive privilege for useful inventions, to increase the priority time from 6 months to 12 months, and to exclude the importers from the definition of the inventors. A few years later, it was felt that designs could also pass the criteria of invention, and thus it should be included in the act. Therefore, a new act known as the Patents and Designs Protection Act, also Act 13 of 1872, was introduced. So the objective of this act was to include the designs as invention. Now this act was amended in 1883 to include the provision of protection for novelty in the invention. Now suppose if an invention is disclosed in any governmental exhibition, then the inventor can file the patent within 6 months after the exhibition. So this period, 6 months, is called the grace period. So therefore, within that grace period, the invention involves novelty criterion. However, after 6 months, it will not pass the novelty criterion and cannot be patented. Now, at the beginning of 20th century, all the earlier acts related to inventions and designs were replaced by a new act known as the Indian Patents and Designs Act, or Act 2nd of 1911. Now, according to this act, the governance of patents was placed under the management of the Controller of Patents for the very first time. Now, in next 30 years, many amendments were introduced in the act, such as use of invention by the government, patent of addition, enhancing the term of the patent from 14 years to 16 years, filing of provisional application and submission of complete application within 9 months from the date of filing the provisional application. Now, after India got independence in 1947, many patent experts felt the need to review the Indian Patents and Designs Act of 1911. Therefore, a dedicated committee was formed, which was known as the Patent Enquiry Committee. The chair of the committee was a renowned judge, Bakshi Tek Chand, who was a retired judge of Lahore High Court. So the committee was formed in 1949 to review the patent system in India. The main objectives of the committee were to survey and report on the working of the patent system in India, to examine the existing patent legislation in India and to make recommendations for improving it, to consider whether any special restriction should be imposed on patent regarding food and medicine, to suggest steps for ensuring effective publicity to the patent system and to patent literature, to consider the necessity and feasibility of setting up a national patents trust, to consider the desirability of regulating the profession of patent agents, to examine the working of the patent office and the services rendered by it to the public and make suitable recommendations for improvement, and to report generally on any improvement that the committee thinks fit to recommend for enabling the Indian patent system to be more conducive to national interest by encouraging invention and the commercial development and use of inventions. Now, these recommendations, like the committee submitted its recommendations, such as misuse of patent rights needs to be prevented. There must be a clear indication in the Act that food, medicine, surgical and curative devices should be made available to the public at the cheapest rate by giving reasonable compensation to the owner of the patent. And it also recommends the amendments in section 22, 23 and 23A of the Patent and Designs Act 1911 on the lines of the UK Patent Act. Now, these recommendations were introduced in the Act 32nd of 1950. 2 years later, another amendment was made to provide compulsory licensing of patents related to food, drugs, chemicals and microbes. Based on these amendments, a bill was presented in the Parliament in 1953. However, the bill could not become an act because it was lapsed on the dissolution of the first Lok Sabha. Now, in 1950s, medicines were imported from foreign countries, and therefore, public of India were not getting the medicines easily. And also, the lack of indigenous medicines and their huge demand led to very high prices of medicine in India at that time. For example, the prices of drug in India were highest in the world. Therefore, in 1957, central government constituted a powerful committee to revise the patent law to comply with the industrial needs. The committee was chaired by Justice N. Rajagopal Iyengar. The committee report was comprised of 2 segments addressing a general aspects of the patent laws and the bill rejected back in 1953. The report of the committee was submitted in September 1957. This report recommended many major changes in the law which formed the basis of the Patents Bill 1965. Now, this bill was introduced in the Lok Sabha on 21st September 1965. However, it was again lapsed with the dissolution of the Lok Sabha in 1967. Now, in 1967, an amended bill was introduced which was referred to a joint parliamentary committee. So, on the final recommendation of the Iyengar's committee, the Patents Act 1970 was passed by the Parliament on 19th September 1970. Now, this Patents Act 1970 is for the protection of patent only. For protection of designs, the 1911 Act was continued. Now, the Patents Act came into force on 20th April 1972 with the publication of Patents Rule 1972. Now, for your information, world's first patent was granted to Samuel Hopkins in USA for the making of potash and pearlash by a new apparatus and process. So, this was given on 31st July 1790. Now, the first patent in India was granted to George Alfred D. Penning from Kolkata for his invention, an efficient pankha pulling machine. On 3rd March 1856, D. Penning petitioned for grant of exclusive privilege for the invention. On 2nd September 1856, he submitted the specifications for his invention along with drawings to illustrate its working. Now, these were accepted and the invention was granted in India for the very first time. Okay, so thank you and thank you for watching.